So I'll start without further ado. So, ladies and gentlemen, and my esteemed panelists, all the attendees, good morning, afternoon, or evening, wherever you are, and welcome to our Jus Mundi Agora series webinar. My name is Alexandre Wagenheim, and I'm the Vice President of Global Legal Data at Jus Mundi. And on behalf of Jus Mundi, I extend a warm welcome to you all. Few words about this Agora series. The Agora series is an initiative from Jus Mundi Academic Network. It's a network of high-profile members of the arbitration community from the academic world, but also practitioner. This network is led by my colleague, Andrew Wilcox, who has been instrumental in building this forum of academics and practitioners to exchange various ideas on salient issues that we're engaging in the arbitration community. And today's webinar stems from the commitment of Jus Mundi's academic network to raise awareness, discuss, and debate the critical intersection of arbitration, climate change policy, and renewable energy investments needed. Few words maybe on the interconnection between international investment and climate challenge. And as all of you know, this is a delicate and very complex topic. From these branches of law emerge conflicting legal obligations, intertwined with a sense of urgency to address humans' greatest challenge. On one hand, we have states which are obliged to reduce greenhouse gas emission and avert catastrophic climate change. On the other hand, the same states are committed to provide foreign investor with a stable and predictable legal framework critically needed for investments to address climate change. We have already seen that states' efforts at climate change mitigation and adaptation have already triggered claims of liability under investment protection under BITs or multilateral investment treaties, and it's clear that there are more claims to come. This has highlighted the urgent needs for reform and to align the investment arbitration system and the arbitration system globally with climate goals. This has caused stark division within the legal community, and we've seen that particularly in the context of the modernization of the energy charter treaties, where we had arbitration lawyer advocating for example, proposing reinterpretation of existing investment arbitration agreement through systemic interpretation, for example, and involving a coherent views of the international legal system, which would include the Paris Agreement, the Glasgow Climate Pact, the EU climate law within the framework of decision. But conversely, we also had many climate lawyers who have lobbied for states to abandon the current regime by terminating or withdrawing from existing investment protection treaties and arbitration. We will discuss further the proposed modernization and the status very shortly. Against this background, we have today our distinguished panelists who will bring a wealth of expertise and insight into these complex issues, and I'm excited to dive into our discussions. So to present you our panelists today, we will begin with Isabel San Martín. Isabel is a lawyer qualified in Spain and New York, specializing in arbitration, dispute resolution, and public international law. She's a senior associate at LALIVE, based in their London office, has an extensive experience in commercial investment treaty cases across various sectors, including, of course, renewable energy, mining, construction. Worth noting, Isabel was also a member of the ICC task force that published the report on resolving climate change-related disputes through arbitration and ADR. Today, Isabel will explore with us the intersection of arbitration and climate change policy and assess whether arbitration can effectively address a dispute arising from climate change regulation. Next, we have Beata Gesell. Beata Gesell is an international arbitrator recognized, having handled more than 150 cases, domestic and international arbitration. She's a member of the advisory body and working group of largest arbitral institution in the world, combined with an extensive academic activity. Today, Beata will discuss the necessity of defining reparation in the context of phasing out fuels, fossil fuels, and explore different paradigms around for phasing. Welcome, Beata. Also today with us, Jessica Brauw. Jessica is an independent arbitrator, international law consultant, and academic researcher specialized in energy, natural resources, climate change, and the environment. Jessica has more than a decade of experience in commercial and investment arbitration, and she is an expert in the law and governance of energy transition. Jessica will be addressing us today on the impact of carve-out clause and discuss the increasing role of carbon trading in domestic climate strategy. Welcome, Jessica. We have Wendy Miles with us. Wendy is a specialist in international arbitration and dispute resolution with a focus on private and public international law. Over 25 years of experience. She has advised multinational, sovereign states, state entities across numerous sectors. In the particular field of climate change and finance, Wendy acts as a global coordinating counsel to various major corporates in relation to climate change, transition, disclosure, reporting, compliance. She regularly, of course, advises investors and states on climate-related physical transition and litigation risk. Welcome, Wendy. Last but certainly not least, Marnix Leijten is joining us from the Netherlands. Marnix has also more than 25 years of experience. Is a counsel in major dispute in international arbitration and litigation across many sectors. And Marnix will be discussing today with us the intersection of human rights, climate change, and corporate responsibilities. So we have a very packed agenda, as you may have heard from my brief introduction of our speakers and the topic, with rich content and diverse perspective. Few administrative aspects. You have a chat box, but most importantly, you have a Q&A box where you can feel free to engage throughout the presentation, to ask directly and live your question. We will do our best to address them either along the way of the presentation and the discussion, or in any case, we've reserved a good 10 to 15 minutes at the end to really address and engage with you and address your questions. So really feel free to, although this might not seem very interactive, and it's a webinar, of course, we want you to be as much part to this Agora series with us as possible. So again, welcome all to this Jus Mundi Agora series on the urgency of reform on the intersection of climate change and investment arbitration. So without further ado, I will start with you, Isabel, and let me ask you a general question to kick things on. You have been involved in many recent investment arbitration cases, especially in the renewable energy sectors. And what are the implications for the future of investment arbitrations?
Thank you very much, Alexandre. And I mean, that is, of course, not an easy question to answer, certainly not in a very short amount of time. So I think it would be helpful. I thought about sort of setting the scene by explaining a little bit the types of investment treaty arbitration cases that we've seen so far, both in the renewable energy sector and sort of the fossil fuel sector briefly, and then discuss how treaty reform can and should play a role. So over the last decade or so, we've seen many states become more aware of the need to change their energy policies, transition their economies in order to combat climate change. And this has, of course, led to increased regulation, changing policies, a need to develop new technologies, and of course, a need to attract a huge amount of investment that is necessary to really make all of this possible. And we know with increased regulation and with these changes comes, of course, an increase in disputes, in the number of disputes. And in investment treaty arbitration in particular, we've seen and we are still sort of seeing, I would say, two broad categories or groups of disputes. The first group of cases are all of those involving renewable energy investments or sort of clean energy investments. I'm sure everybody is familiar with all of the cases against several European countries, including my home country, Spain. So as many European countries sort of attempted to increase the proportion of energy produced from clean sources, they designed systems of incentives in order to attract the needed investment in renewable energy. And those technologies at that time were still very, very expensive. They were not mature. But then after attracting the level of investment they needed to meet those targets, some of those countries like Spain, Italy, or the Czech Republic, then they made changes to those regulatory regimes, and they negatively affected existing investments. But in addition to those cases under the Energy Charter Treaty, I think we've seen other examples of cases related to the backsliding on climate change goals, and you see that there are different reasons for that in different countries. So one example, for instance, is Mexico's energy policies, particularly under former President López Obrador. And there, the types of measures that we've seen not only harmed renewable energy investors, but they did so in order to favor energy produced by the state-owned company, CFE, despite that energy being sort of much more polluting. It wasn't produced from clean energy sources. So there was a different sort of objective there. Another example that I would include under this first category of cases would be the case of Windstream against Canada, the first case, the one that was decided in 2016. I know there is a separate case that is pending, but on that case, the state of Ontario adopted a moratorium on offshore wind projects, which affected some projects that were being developed at that time. And in the arbitration, Canada argued that the decision was driven by the fact that they didn't think there was sufficient scientific sort of research yet on offshore wind, that it was a new technology. And the tribunal in that case found Canada in breach of NAFTA. That was the treaty that applied in that case. And it did so by concluding that the decision to adopt the moratorium, after looking at the evidence, was largely influenced by public opposition more generally to offshore wind. The fact that I guess citizens didn't like the idea of having offshore wind farms. And in particular, the tribunal also found that the government at that time was worried about how that would impact them in the upcoming elections that they had. So it was also sort of like a political decision. So these are just, yeah, some of the examples that I would include under this sort of first category of cases. And I think treaty reforms can certainly play an important role in cases involving clean energy sources and renewable energy investments. We've seen some examples already of this. For instance, what are called the clauses on non-lowering of standards. They're included in a large number of new generation treaties, actually, and essentially states they commit not to encourage investment by lowering their environmental standards. This is, for example, the US model BIT first included this kind of clause. Another type of clause is what is called non-regression clauses. There is an example of this in the UK-EU Trade and Cooperation Agreement. And under those clauses, states commit not to reduce their environmental protections in a manner that would affect investments. So those are sort of some of the examples of clauses that could be introduced to reform treaties. Moving to the second group of cases that we've seen so far in investment treaty arbitration, it's those related to the phasing out of fossil fuels and of certain energy sources, essentially coal, oil, and gas. So these are measures, that states would adopt in order to reduce their carbon emissions and to try to meet their climate change goals. We've seen a lot of cases already, not many that have concluded. So for instance, there were a number of cases against the Netherlands for phasing out coal, but they were both, I think it was 2 cases, they were both discontinued. There was another case against Canada, also in relation to the phasing out of coal, but the tribunal found it had no jurisdiction. And then there are at least 2 other cases that are currently pending. One against the US over the Keystone XL pipeline, another one against Lavinia over a ban on hydraulic fracking. So the big question really on this sort of second category or group of cases is how are they going to be decided by tribunals? And here I wanted to just spend a couple of minutes discussing an example, which is the case of Rockhopper against Italy, a case where the tribunal found the state liable. And then I know that Beata will discuss this case in relation to damages. So I'm just going to focus briefly on liability and then in particular on the Energy Charter Treaty, because that was also the treaty at issue in that case. So just really briefly to explain what the case was about. So the investor, Rockhopper, it acquired its investment at a time when Italy had adopted a ban on offshore drilling projects within a certain distance of its coastline. And the ban had been amended in order to clarify that it would not apply to projects that had already applied for a concession or exploitation concessions before 2010. And that was the case of the investor in this particular case, Rockhopper. They had submitted that application before that deadline. Now, Italy then issued a decree and it approved Rockhopper's environmental impact assessment for its concession. But then a few months later, the Italian parliament passed a law where it removed that exception to the drilling ban. So the ban then applied to all projects, including those that had pending applications before 2010. So essentially, Italy rejected the claimant's concession application, and the tribunal found that this was an unlawful expropriation and that it breached the Energy Charter Treaty. And one of the arguments that Italy made in that case was that the measure fell within the police powers exception because of environmental reasons. And the tribunal there found, and this was based on witness testimony at the hearing, and then also documentary evidence from the parliamentary debates in Italy. The tribunal found that Italy had not rejected the concession, the application, the concession application, sorry, for environmental concerns, but rather that it was done for political reasons. And this was very briefly, but because there were some tensions between the central government, the regional governments, and the federal government wanted to avoid having to hold a referendum on this issue, so they decided to adopt the law. And one of the findings that was critical to the tribunal was that Italy had already approved the environmental impact assessment for the project. So I mean, this is a case that has been widely reported. It has, of course, given rise to some criticism because it concerns the oil and gas sector. And I think it's just, I mean, it's very interesting case and really, I think, shows sort of the importance of looking at the timing of the measures, the timing of the investment, and sort of the evidence surrounding the adoption of the measures. And so that case was decided under the Energy Charter Treaty. And of course, I think, I mean, the modernized Energy Charter Treaty, which at this stage is not very clear if it will see the light. But I think this kind of case shows how sort of treaty reform could actually play a very big role. I do think that future cases involving fossil fuels could be decided very differently under modern treaties like the Modernized Energy Charter Treaty. And just to sort of give a few examples of the kind of language, it's kind of clauses in the under a modern Energy Charter Treaty. It includes, for instance, a standalone provision on the Paris Agreement specifically, so the contracting parties reaffirm that they have rights and obligations under the Paris Agreement, and they include that expressly in the ECT. It recognizes explicitly the state's right to regulate, in particular on climate change mitigation and adaptation. And then, of course, there's the fossil fuel carve out and other sort of mechanisms to review the types of investments that the contracting parties want to protect over time, and that they intend to adapt this to sort of the evolving science and their priorities and their specific sort of climate change goals. So I think we will certainly see more and more of these kinds of cases. And I think it shows the importance of sort of the states aligning or trying to align their treaties to this new reality. This new reality. And I would just end this by saying that the majority of investment treaties that are still in force today are old generation treaties. And there does not seem to be yet a clear consensus on how to reform all of these treaties. So the process is still moving a little bit slowly, but I think I'll leave it there for now.
I think thank you very much, Isabel. And again, you refer to the ECT and the uncertainty of of where we are at the moment. Maybe most of you know, but if you don't, last month on 26th of June, I think 26 out of the 27 member states of the EU made a declaration to have the ECT inapplicable between them for ongoing and future arbitration. Of course, it remains to be seen how this declaration will be interpreted by tribunals if they have to interpret this declaration. But what we're seeing is that there is a strong, at least for what concern the efforts to modernize the ECT, there is a strong on this side of the Atlantic opposition to any effect on the modernization efforts that were made. You mentioned something interesting in your proposal of reforms, or at least trying to tell us what kind of ways of reforms there might be on the treaty aspect, but also on the wording and the clauses of the BITs. But one of those clauses is precisely the carve-out clause, and I think we discussed that with a little bit with Jessica. But what could be, and I'll turn to you, Jess. What could be the effect of this carve-out clause, and what would be how we would see an impact of those clauses in the reform process that we're discussing?
Well, thank you, Alexandre. And I think I will start by picking up on one point that you just mentioned, which is the tensions and some of the resistance that has been become growing and more evident, particularly in Europe, against ISDS. Where we're starting to see more of these fossil fuel cases hitting headlines in the news in Europe and globally, in particular for the amount of damages that are being awarded in respect of the cancellation of some of these projects. And so both in terms of fossil fuel kind of decarbonization, as well as when we think about it in terms of the nexus between investment protection and green investment, one of the issues that's often really overlooked is just this intention that's inherent to the proposition that more legal protection should be given to foreign investors in order to attract climate and Paris-aligned investments, and what is being proposed in some of the reform discussions surrounding environmental carve-out and right to regulate provisions. And I'm talking really about this idea that states should be granted more regulatory freedom to enact climate and energy policy in line with the objectives of the international climate change regime, and the tension that can arise from the fact that this will, come head to head with some of the stronger protections that are granted to investors in order to incentivize some of that investment. And so these conflicts at the environment and investment nexus are really of growing concern, I think, and of course they are a huge topic in international arbitration. But if we also think about it in terms of the synergies that are at this nexus, in order for the climate change regime to function properly, we need both rapid and deep decarbonization, but we also need financing and capacity building. And we need those finance flows to be directed towards climate vulnerable countries and least developed economies. And those financing flows will go directly towards, financing nature-based solutions, which can feed into market mechanisms like carbon trading, for example. You also have them naturally feeding into scaling in alternative sources of energy, building up infrastructure in order to meet adaptation needs and goals, and also to compensate for the opportunity costs of keeping fossil fuels in the ground and not exploiting reserves. And this feeds into some of the kind of underlying justice elements of the international climate change regime, which are encapsulated in the principles of common but differentiated responsibilities, in ensuring that there is an element of equity when it comes to, the burden and the opportunities of the energy transition. And so if we come back to this premise, the premise that has been discussed quite a bit, I think certainly in the context of international arbitration and investment arbitration in particular, that investment treaties and enhanced investment protection in particular can provide market access to foreign investors, which will pave the way for more of these green investments. And I will caveat that there are some academics and practitioners and policymakers who do refute this suggestion and say that it, at best still remains unproven, but it certainly is something that has been demonstrated as possible to unlock volumes of investment into climate vulnerable countries that's needed. But that said, I think that the main issue, at least in the immediate term, is that currently the investment treaties facilitate market access to any type of investment. And so while at the same time, this is going to constrain the legal space for states to transform their economies. And so that you can see how it can create tensions and it would not necessarily support the efforts for climate change. And if you accept that, then you can see how granting more legal protection to foreign investment with the supposed aim of attracting more green investment, is going to cause issues when it comes to the regulatory margin of maneuver for states, when it comes to climate and environmental policy, and these are going to be at odds with each other. But if we come back to the theme of reform, and we come back specifically to the topic that you asked me about, one of the solutions that has been proposed is that investment treaties could be used to facilitate market access of genuinely green investments, provided that they're being drafted, amended, and interpreted in a way to provide more leeway for states to actually adopt and manage climate policy once an investment is in place. And in this context, we've seen the growing use of environmental clauses in BITs and FTAs. We see them as often in annexes to expropriation clauses, carving out environmental regulations, or interpreting them consistent with investment obligations. But the operation of these clauses is really at a crossroads. We have some jurisprudence coming out now where we've seen tribunals interpret some of these clauses. And we also see that they have the potential to operate in a number of different ways. They can either exclude jurisdiction altogether, they can create a presumption of conformity with the agreement, they can serve as interpretive guidance for trying to understand the way in which international investment law and international environmental law should be interpreted, as two coexisting branches of public international law. And they can also operate as a restrictive exception. And I think one of the best examples that we've seen so far is that we now have 3 different cases on the Canada-Colombia free trade agreement from 3 different tribunals. Some overlap on the composition of the tribunals amongst the 3 of them. All 3 cases in the mining space brought by Canadian miners. Of course, the mining space is going to be one that is more and more, implicated at this intersection between investment law and the environment as, an upstream component of many forms of renewable energy. All 3 of these cases concerned a mining ban in the Colombian Paramos, which is a fragile ecosystem. And all 3 of the investors brought claims alleging that the measures that were brought by Colombia, which were aimed at protecting and delimiting the wetlands, gave rise to violations of the minimum standard of treatment under international law, under the treaty, as well as expropriation. And so this treaty is a treaty that contains an express environmental exception that preserves the right to regulate for human health and the environment. But what's interesting is that we saw 3 different outcomes in all 3 cases with 3 different tribunals interpreting this clause. In Eco Oro, we had the tribunal majority considered whether the environmental exception operated as a defense on the merits, but really only with respect to the obligation to pay compensation once liability or state responsibility had been engaged. Interestingly, in Red Eagle, there was no finding of breach, and so no state responsibility was engaged, and so it didn't analyze its operation, so we don't know how or where that tribunal would have fallen. In Montauk, they agreed with the interpretation of the operation of the exception clause with Eco Oro, but they didn't find that they did not find that there was a breach and therefore it did not operate, but they did find that it would have given rise to an obligation to compensate if liability had been engaged. So I think interestingly, the jury is really still out. The operation of the clause is, of course, going to depend on its wording and its context, but in practice, it's also going to be affected by the way in which it's pleaded by counsel in amicus briefs and the specific composition of the tribunal and their views. And so for those reasons, it's a little bit difficult when we're thinking about it at the reform stage and the drafting stage to control the way that it's going to operate in practice. And this is where a lot of criticism has been levied at the reform process from organizations like Client Earth or from the Institute for Sustainable Investment at Columbia University. So I think I'll just leave it by saying that the jury is still out to see the way in which these these attempts at modernization and these drafting efforts in order to ensure that there is better alignment between the 2 branches of international law will actually operate in practice.
Thanks, Jessica, and I think both you and Isabel have really brushed the various issues that we encounter at the intersection. You mentioned the contested argument about whether actually investment protection promotes investment, and we hear that you advocate it as a way to facilitate market access to green investment. Any immediate reaction to our other panelists on this on the framework and the ideas of reform that have been advocated so far? Wendy, Marnix, Beata. All right. Maybe something before we move to the next chapter of this webinar. Perhaps what's also interesting, and I think there is I've just read a synopsis of a current PhD by a young lawyer from Queen Mary called Thomas Lehmann, and his thesis was precisely examining how international climate change law was impacting the legitimate expectation of foreign energy investors. And the proposal was to integrate actually climate change norms into the assessment of foreign investor legitimate expectation. This is definitely a piece to watch on that debate that we're having. I think we'll turn now to a second part of this webinar, which is really focused on one of the critical aspects of this intersection, which relates to damages, reparation, and the paradigm. For that, we'll have two intervention, and hopefully this will generate some questions and thoughts. I'll start with you, Beata. And let me ask you this again. I'll start with very general questions, but what are the implications of different paradigms for phasing out fossil fuels, on the computation of damages in arbitration cases?
Okay, let me tackle this topic based on one very distinct type of this kind of disputes. I mean this rock hopper case type. And as already Isabel was speaking, this is why is it special? Because this dispute, the claims were raised by the investor for the expropriation, which was done for the right to be granted a license. So we are talking about the such projects which are predicted to have a final investment decision, but for which at least an exploration permit had already been obtained by investors. So I would like to focus on this type of things because I think that this is very critical, and it appears that we are facing about more than 50,000 globally, more than 50,000 of such projects, and they can generate claims in the value of more than 300 billions of dollars, in the future. So we are talking about the real problem. And the great contribution into such scale of reparations was granted to the increasing use of the discounted cash flow methodology. And it has been noticed by Ancestral Working Group that they made such computations that before 2002, the DCF was used in only 17% of cases. And then there was a made computation between 2011 and 2015, so for 4 years, and it happened to be about 70%. So look at this, how much it increased, the usage of this quite speculative methodology of making computation of claims. If you're talking about the paradigm, I think that we have to tackle one thing. It is make the first assumption, which is that not investors alone, but also not states alone should incur all the burden connected with the fighting, struggling against climate change. It means that there must be some action in concert. There must be certain fair balance between interests of both sides. And this is not me, this is raised in very many articles if you are looking at them. And I think that it is very important to say that this is our global good. It means the fighting with the climate change, environmental issues, this is our global good. And if I can just come back to the Jeremy Bentham, who said that it is sacred truth that the greatest happiness of the greatest number is the foundation of morals and legislation. So if you're talking about the paradigm of compensation, I would even go so deep back, in history. And I'm sure that if Mr. Bentham would have lived today, he definitely would rank preservation of climate as the greatest good for the greatest number. So I would say this is the global good which has to be preserved. So then what does it mean? That all measures which are aimed at decreasing the level of the greenhouse gases, all of the climate preservation measures, they are not just done for one nation, for one state. They are done really in our global good. And this also requires a more common global support. So following this issue, following this premises of this global good, I think that there are some trials to balance the interests of the state and the interests of the investor. And for example, there is the Ursula Kribam, who was speaking about the Austrian academic about balancing this interest in terms of compensation. It means she's speaking that right now, this is what she observes. I do not fully agree with her on this, but she says that what she observes is everything or nothing. It means all 100% of compensation goes to the investor, or 100% goes to the state. This is not, I think, exactly true if you are looking into these measures which are undertaken. But she says that even if there is the expropriation ascertained or other acts of the state, this balancing can be made by awarding more than the full market value of the investment as such. And she gets back to the International Court of Human Rights and speaks about the former king of Greece versus Greece. And, there was the claim which was done against the Greece, and the assets which were claimed, that was about 500 million euro. And the court considers that in a case where there is a fundamental change, there is a fundamental thing, such as the transition from monarchy to republic, this fair market value can be diminished based on general equity principles. The second approach is done based on the unjust enrichment. In this context, for example, there is the case of Tetian Copper against Pakistan is quoted. And, if we see the outcome of this arbitration, and basically, as I understand, the amount invested in this made by the investor was 250 millions. And what was recovered, that was more than 4 billion. So it makes 17 times money. If we compare it with the regular private equity funds, which are operating on the high risk level of investments, this is usually the average is no more than 10% per annum, the 10.5, something like this. So this is something would give rise to thoughts related to the unjust enrichment, especially that such unjust enrichment, they are common to all of the legal orders, most of the jurisdictions. And now, if I can focus on the Rockhopper case, already Isabel was speaking about the facts. So as I say, we are in between. The Rockhopper purchased, what is important, purchased shares in 2014. Sorry for being so specific about the dates, but this will be important for me in showing how these damages were calculated. So in 2014, Rockhopper buys shares in the company, which has the shares in the company which is exploring, the gas and oil in Adriatic in nearby Abruzzo, a beautiful area. And they purchased the shares in the company which had already a license to explore near this coast of Abruzzo and a pending application to obtain a drilling license. As it has been said, that was a kind of a license roller coaster because there was changing in the legislation. So once it was agreed that they can explore, then there was a change of law that they cannot explore, then they bought the shares, then there was this carve out for these pending applications, and then there is the application of Rockhopper. They get this decree on confirming their conformity with the environmental laws. Then 6 months later, there is a change of law again, and there is a denial of license. And what happens then? There is massive protests. I think we have to understand what is the climate around this, not climate change, but climate atmosphere, the social atmosphere around this situation. In one place, there's 40,000 people protesting. In another place, 60,000 people protesting. So these are enormous actions. Academics, scientists, activists, everybody is protesting because what happened earlier? There was this disaster at the Gulf of Mexico. It showed what can happen if there is a spill out of the oil in the sea. And then what kind of compensation could such an investor expect in the situation? And I was trying to make such an exercise of escalating, the damages. Because firstly, as was rightly said by Isabel, there is the police powers doctrine, and that was the defense of the state. That was not upheld by the tribunal. They said that that was political reasons, because they, in August 2015, this decree on confirmation of the environmental issues was issued. So it means that since this moment, the state lost its right to raise police powers, because it said it's okay. From the environmental perspective, it's okay. However, there was a change of the law later on. It means after this decree was granted, but not the application. That was not license granted whatsoever. So in case we take these police powers, defense is correct. There is no compensation at all, because if police powers are used, there is no pooling for compensatory measures. The tribunal said no, police powers were not used in this situation, as I already said. So then the tribunal said that in August 2015, when this decree was issued, there was a very striking moment. Beforehand, there was a hope. Exactly, I'm quoting the tribunal. Beforehand, there was a hope to receive the license. After the decree, there was a right to be granted a license. And the tribunal said that this right was really expropriated. There is more to say what was really expropriated in this situation from the legal perspective. But anyway, if we follow the findings of the tribunal and we see that there is a hope until 2015, August, and then after is a right. So all of the investments really done before this transformation date, I would say, this is not the covered investment. So basically, the second layer of compensation, what could be awarded, was that this is really only investments which were done after August 2015 could be subject of investment coverage. So that was probably like a few 2-3 million euro, which has been invested after hope was transformed into the right. That was not taken as proper by the tribunal. So let's go at the higher level. So more. We have the situation which in normal circumstances, under normal circumstances, that like with the contract, if the contract is, there's the promise to have a contract, the contract is not cut. This then usually in common law and in civil law, the investor could have the compensation based on so-called negative interest or reliance interest. It means that he cannot claim for the profits which can be generated based if the contract has been signed actually, but only the costs which he incurred with the relying that the final contract is done. The tribunal did not even touch base on this. Then the tribunal really referred to the discounted cash flow. And we have the situation that the climate itself is presenting the different analyses, and it is so speculative. It says that based on different variables, we can manage to have 88 million or 1.5 billion. So even Climate, when he was proposing his own different calculations of the discounted cash flow, he was in such a, different, in such extremes. Just to cut long story short, the tribunal based its findings on DCF, but not on the DCF which was proposed by the parties in this arbitration, but it has decided that DCF which the company has made for itself when they were buying the company, and they were made for their internal purposes, which was the less than 200 million, that was okay, and he based on this. And what is really annoying in this situation is that first, that was the tribunal did not really put much attention to the police powers. There are 2 paragraphs, to other measures which can be undertaken for the compensation. There is, for example, Rusoro mining case, in which it is stated that if there is no established profitability of the company, you cannot really apply DCF. In our case, there was nothing. It means there was, before the license, they really couldn't really start production of oil and gas. So there was nothing, and they have got the the profits which they could have earned, I don't know for how many years, this profit was discounted. And that was the tribunal did not really worked on this. So they based, and this is my last comment, because I think this is, when you see all of these awards and you look into this, what is always quoted as a Bible? The Chorzów factory case. And the Chorzów factor is always spoken that that the award must, as far as possible, wipe out all the consequences. But what does it mean, wipe out? I have a feeling that not too many people really look into this award, because it was exactly, there was instructions for the experts done. There was the factory which was ongoing business, the ongoing concern. And the indications for the experts to make their evaluation was done in the way that you have to calculate the value of assets, so real estate, movables, licenses, patents, and so on. That was one thing. And the second, you have to calculate profits or losses, which could have been incurred until the moment of the decision. No discounted cash flow, no something like for future, like 20 years, in front of us. That was until exactly the experts were supposed to make such a computation based on this exactly until the moment when they were making this decision. So I think that using the Chorzów case, which is Polish case, so I really like it, it means unfortunately against Chorzów, against Poland, but using this is a little bit of exaggeration, because there is nothing, this wiping out, which is always repeated, there is nothing which really empowers us to adopt the discounted cash flow measure. Thank you.
Thank you very much, Beata, and thank you for the passion that you in raising those issues, and they are indeed very central to the criticism that the investment arbitration regime has been handling for the past few years. I know we have, and I will come back to you, Beata, on more concrete maybe answers of reform in the damage phase, but I will just turn to Wendy now in the interest of time, as she's also discussing, and so we can have also a parallel on the various points that you may have mentioned, also on the commercial arbitration aspect. So Wendy, I'm turning to you again with my ever general question to start to you. First of all, I think we are discussing a lot investment arbitration, but commercial arbitration indeed has a role, and perhaps what should be the role of commercial arbitration in resolving disputed related to renewable energy and climate change generally, and why is this important? Before turning to the damage aspect of it.
Sure. So let me just try and contextualize a little bit. And to answer Thomas's question in the Q&A, which was to Beata, but no, the tribunal didn't raise climate change in the Rockhopper Italy case, because the Rockhopper Italy case wasn't a climate change case. It was an environmental case. It was preserving the offshore territory for environmental purposes. It had absolutely nothing to do with reduction of greenhouse gases. And it's important just in the context of when we're talking about investor state arbitration, which I wasn't planning to talk about, but none of the cases that has ended in an award has dealt with phasing out of fossil fuels. Not a single one. There have been cases in Isabel's first category, she's quite right, in the scaling up of the displacement activity, of the renewables activity in the energy transition, which is just one of 4 transitions for climate change purposes. But there has been no case that has gone to award on climate change mitigation, reduction of greenhouse gases. The RWE Netherlands case settled, the Uniper Netherlands case settled, the Koch brothers, which I think is the coal case you're talking about, the Koch Industries case under NAFTA, was determined against the Koch Industries on jurisdiction. It wasn't actually a coal phase-out case. It was a phasing out of Ontario's free allowances under its emissions trading scheme. So it was an ETS carbon credits case. There is a case pending, Zeph Industries and Australia, that is about the decision of a local council not to grant a coal mining license, including on the ground of scope 3 emissions of the ultimate combustion of that coal in its final market. And that's been challenged on the basis that it's not a relevant consideration under the mining decision. It may or may not get to an award, but there's been a lot of criticism about investor-state arbitration, decisions not being consistent with the phasing out of high emission activity. But there hasn't been a case, there hasn't been an award. So it's a little bit misplaced, some of that criticism. And I think we within the community who know the case as well should just be a little bit careful not to foster that confusion. So I was going to just take a step back about the topic and the urgency of reform, arbitration at the intersection of international investment law and climate law. And just, although my primary task is to focus on commercial arbitration in relation to investment and climate, I think we need to think about the 4 key elements in the topic that Alessandra and Jus Mundi have put before us: the urgency, reform, international investment law, and climate law, and what we mean by those things. So reform, in my mind, means to make an improvement to a system, a law, or an organization in order to make it more modern or more effective. So reforming the economy, reforming the tax system, reforming the mechanism of resolving investment protection disputes. Reform doesn't necessarily require radical redesign, rewrite, or replacement of an entire system. Improvement can be incremental, and it may be procedural, or it may be substantive, or it can indeed be both. Do we need reform to deal with the intersection of international investment law and climate law? Well, I would say yes, but is reform as radical as proposed in some of the campaigns against investment protection? I'm not convinced it is, and I think the perverse outcomes of burning down the investment protection house will cause a lot more harm than the worst ills of the mechanisms as they currently operate. In terms of urgency, do we actively need to progress with improving our system? I would say yes. I've been saying that since the Paris Agreement was signed in 2015, and I'll keep saying it. But active improvement needs to be undertaken with care and with responsibility. We as a community have to be involved in that. We can't just duck down and protect our own interests. We need to deal with it face on. We are all in a transition, including our international arbitration community. But we need to understand, if we're going to talk about reforming investment protection, we need to understand what we mean by investment protection and why it exists, what its purposes are, why it was created in the first place, before we make decisions either to abolish it or to create radical reform. Do you know, I Googled how many people die in car accidents per year, and you know it's 1.19 million people per year die in car accidents. Does that mean we eliminate cars in order to save lives? And I think this is, it's just important not to throw out the baby with the bathwater in reform. Just let me try and...
You can take a moment. Maybe Beata, I see you wanted to raise some points while Wendy is coming back. Do you want to interject on?
Yeah. Because Wendy said that this is not phasing out case, and I think that on one hand she is right. So I respectfully agree. It means that the tribunal did not really tackle the issue of the climate change in this situation and phasing out issues. But that was also the subject of criticism against the tribunal, because if you look into the files, it means into the body of the award, it is said exactly that the state was calling that the change of the law, which was done at the end of 2015, was done due to the change to the with the aim to change the structure of the fuels, and in order to implement the Paris Agreement. So in these terms, yes, this is phasing out. It means that was not really dealt with. There were some also criticism against Italy as a state, that they did not really raise more precisely and more expressly the climate change issues. But that was in the files, and that was the critical issue against the tribunal, that they did not really follow and did not really react to this line of the interpretation. Sorry, Wendy, I don't know how much you have heard.
No, I'm sorry about that, Beata. Are you done? I had the class I'm teaching had all exited and were chatting in the hallway where I was hiding, but I found a quiet place again. Yeah, it's important to read that Rockhopper decision. So international investment law. So I in terms of urgency and reform, you know, I'm there as much as anybody, but urgency and reform means different people, different things to different people. And I think we should be clear about what we're talking about. So also, if we're focused here on the intersection of international investment law and climate law, what do we mean by those things? And again, different things to different people. International investment law, in my mind, encompasses all of those modalities and mechanisms that exist in public international law, national domestic law, and private international law that provide an enabling environment for the movement of capital, trade, and investment across borders. It's not limited to bilateral investment treaties. It's not limited to the investment Charter Treaty. It's not limited to any particular instrument or type of instruments, and it's certainly not limited to ISDS. So from a public international law perspective, we have bilateral investment treaties, multilateral investment treaties, investment chapters of free trade agreement. We have the ICSID Convention, but we also have the New York Convention on the enforcement of foreign arbitration awards, which applies oftentimes in those investment treaties, but also in pretty much most cross-border investment agreements that provide for international arbitration. At domestic law, we have investment protection statutes, we have UNCITRAL model arbitration laws, and we have myriad sector-specific frameworks to protect investment in utilities, mining, energy, infrastructure, pretty much any sector you can imagine. In private international law, there lie our contractual instruments that form the foundation, as I said, of pretty much all cross-border trade and investment. So when we talk about investment protection, we have to think about it in its totality, in its whole system. And in order to meet the Paris Agreement objectives, we need to mobilize finance flows into investment in mitigation, in adaptation, and in resilience building. So we need all of these investment protections. So it's really important that we frame this conversation. We're talking about the intersect of investment protection, that we don't limit it to an argument about ISDS. Because what I fear is if the valid criticisms in many respects of ISDS and some of these potentially aberrant award outcomes it were to lead to a situation where there is uniform abandonment of ISDS, as we've seen with the withdrawal of the Energy Charter Treaty, the risk is New York Convention will follow, ability to enforce cross-border agreements outside of the courts of the state that might have expropriated will follow, and we will actually have back to mid-20th century Wild West gunboat diplomacy, and not to be extreme, but this is we do need to be careful about what we're talking about. And then when we come to climate law, again, what do we mean? When I talk about climate change law, I don't mean environmental law. I don't think we should be doing anything that's inconsistent with international or domestic environmental laws, or indeed human rights laws. But climate change law is different to environmental law. It is about removing the cause, the excessive greenhouse gas emissions, in order to reduce the carbon level in our atmosphere, in order to make this planet inhabitable to our species and millions of other species in the long term. So against all of those framework statutes, regulations, governing finance, tax, mining, energy, utilities, infrastructure, as I said, they all lie at the heart of this transition. So I think the two really important things, and then I promise I will come very quickly to damages, Alessandra, but I think the two really, really important things are we have to be so careful not to get stuck in our own little echo chamber silo of either ISDS or investment protection treaties, or even international arbitration to protect cross-border trade and investment. We have to think about how money flows across the world. And then we have to understand and really understand what is going on in the UNFCCC negotiations and what 195 countries are committing to do under the Paris Agreement in order to build those new investment strategies under each one of those state parties, nationally determined contribution, how that's being implemented into policy. And I think just building on what Beata and Isabel in particular were talking about, Jessica too, is I think there's three ways that we reform within the mechanisms we are operating, but we just think about what this transition looks like in the global economic system. One is we think more in a more nuanced and a more sophisticated way about applicable law, that we understand the conflicts of public law instruments. We understand the Vienna Convention, and we actually talk about, we don't need to change every single bilateral investment treaty because we have the Paris Agreement as a subsequent treaty. We just have to read them in accordance with conflict of law and applicable law principles. We understand the role of domestic law. And when states are implementing new domestic laws to enforce their transition, we understand that the breach of a treaty would require those laws to be unreasonable, arbitrary, or discriminatory. If they're not any of those things, and if they're entirely consistent with the Paris Agreement, then we ought to be able to reconcile these two things. If we can't reconcile them, then the Vienna Convention deals with how we deal with subsequent treaties if they cannot be reconciled. So that is there, applicable law. Second thing that's there is expertise. We have not done as well as we could, I believe, as a community of experts in dealing with science, in dealing with economics and econometrics, right back to wholesale factory. If we're going to put you in the position for reparation, we should understand that against the economics of 1923 when that decision was made. I've never seen that argued in a case. So we need to understand economic science as well as the science basis in relation to climate. But then most importantly, and finally, Alessandra, I've got to my point, is damages itself in our damages analysis. I'm shocked by the statistics that Beata said, if I heard her right, going from 17% to 70% of DCF. I hope that is only in investment treaty cases. I doubt anyone would have the statistics on commercial arbitration because that is confidential. But I do think we have an issue in the way we deal with damages in international arbitration, especially in investor-state arbitration. And I don't think it is reflective of what happens in the real world when companies are acquired, when there's mergers and acquisitions, when companies are valued for the purpose of IPO or sale or loan finance. I think we are out of whack. I think we have a situation where claimant's damages expert comes in and asks for as much as he or she possibly can, and respondent's expert comes in and tries to get as close as possible to zero or below. And that's sort of the rules of engagement, rather than properly looking at how the rest of the world values assets and businesses and business opportunities and loss outside of our little echo chamber. And outside of our little echo chamber, fossil fuel assets are taking into account the changing enabling environment in the states where those assets are operating. Renewable assets at different phases of development have different practices for how they're valued. And we need to be able to accept, absorb, and understand that, and get a bit more sophisticated in how we as a community argue damages and make decisions on damages.
Thank you very much, Wendy. And I think this is raising already comments. I see Marnix, you wanted to comments perhaps or raise a point.
Yeah, I think that's very interesting, Wendy. Thank you very much. My point would actually be you're sort of basically comparing DCFs to what is happening in the real world. Even within the context of a DCF, what has surprised me, and that could also be a criticism about Rockhopper, is actually the risk a certain investment would have had if it were not basically taken away, should come back in the discount factor. Now, what you're saying is basically environmental risks and particularly climate change risks are used in actual life to basically value assets and have to be reported on quite soon, at least in the EU, is that when looking at damages, and you know what a DCF is, it's basically predicting the future, and then with a very sophisticated model, but it's still about predicting the future, which even economists cannot do accurately. I wonder why there's not far more of a focus in that there's a significant risk element to certain investments that is added, which should lead to bigger discount factors, which in turn should lead to lower damages. And that looking at Rockhopper, which I think you're right that in the liability was not at all about climate change. I think the missed opportunity is to look at, instead of looking at the DCF that was done in the past, basically do a DCF that takes into account the risk of a fossil fuel investment offshore Italy, and looking at the profits in the distant future. That is in terms of phasing out risks, in terms of increased costs and decreased economics, basically stranded assets, etc.
Thank you very much, Marnix. And I think we so maybe to sum up Wendy's point, I think nuanced approach to applicable law, to expertise, and also to the views on damages. We'll stop here for what concern this second block, and we'll come to our two last points of discussion. One of which is an essential part of the policy reform and supporting the market mechanism, and we wanted to touch upon that maybe with you, Jessica, on trading schemes and what are the lessons that we can draw, at least in terms of future policy reform and arbitration reforms together.
Sure, thank you. Well, I think, in this context, and certainly with the broad background that Wendy just provided, I think it's kind of helpful to understand some of the ways in which policy change at the domestic level is starting to have unintended interactions with the international investment regime. And we're starting to see this with the increasing role of carbon trading in domestic climate strategies. And in this context, I'll talk about the NAFTA case, which I think is probably different from the case that Isabel was talking about. I think she was referring to the Westmoreland case, which was about the coal phase out in Alberta under the Alberta Climate Change Act, whereas this was about the cancellation of the Ontario cap and trade scheme and the delinking with Quebec and California, which had an impact on a US conglomerate who had purchased carbon credits under this linked agreement, which were then subsequently stranded and canceled when there was a change in government, because climate policy operates under a very charged domestic political regime. There was a change in government, there were elections in Canada, and the new government came in and canceled the cap and trade system. But just to kind of give a little background to this, states do have a lot of tools at their disposal to decarbonize as part of their climate strategy in order to meet their NDCs under the Paris Agreement. And one of these is to introduce these so-called market mechanisms, which are really based on kind of old principles of environmental economics about polluter pays principles and internalizing the cost of polluting, which have now been adopted in the context of mitigation strategies for reducing greenhouse gases within a specific territory. And this is also known as, by kind of giving market signals and attributing a price to carbon. And one of the ways in which governments do this is through emissions trading systems. And these are also, again, called cap and trade systems. What they do is cap the total level of greenhouse gas emissions within a specific jurisdiction, and they will allocate quotas to certain mandatory participants, typically heavy emitters. And they can also introduce both voluntary and market participants who don't have obligations, but who can come in and help, make the market operate in such a way that it drives up the costs, it increases the incentives to abate, and it effectively operates, if it's working in tandem with a system that is progressively decreasing the total cap in the system, it starts to actually incentivize actors to adopt, strategy transformation when it comes to their carbon footprint and their greenhouse gas emissions. It's a kind of a simple concept, but can be quite technical. But the way in which this is now actually interacting with investment law is because what we've seen is that in order to actually enlarge markets and to get better, reap some of the benefits from having, more of an enlarged market that you can get, comes through some of the, it comes through by way of, generating increases in price and also, enlarging some of the different industries in which these market touches. It can also operate in order to direct finance flows in different directions. One of the most important things that I think has been touched upon by a number of people, Wendy included, about the importance of ensuring that market flows are being directed particularly towards very climate vulnerable and developing economies. And emissions trading is actually one of the biggest opportunities in this respect, because what they do is they can effectively help drive financing towards really high quality offsets, which can be found in places where you have the opportunity to develop strong nature-based solutions. So, for example, I think it was at COP27, you had the development of the Africa Carbon Markets Initiative, whose aim is to produce, I think, around 300 million carbon credits annually. They are looking to unlock 6 billion in revenue and create a number of jobs around this, because they have a lot of high quality opportunities to create great offsets. And so what that can do is they can either create a regulatory regime where it can integrate into a mandatory compliance regime, or it can work in tandem with voluntary obligations. So this is for companies who, for strategic reasons, may have adopted a net zero strategy, or for companies who are operating in jurisdictions that have due diligence regimes and obligations. For example, if a company is operating or has part of their supply chain that is touched by the new regime in the EU, sorry, it's like it doesn't really roll off the tongue, the C3SD, which it creates obligations across the global supply chain. So what voluntary markets can do is they can unlock the opportunity for corporates to go and purchase, high quality offsets if they are recognized in order to meet some of these strategies, very, very high level. But what happens is when you have international investors who are purchasing these credits across jurisdictions which may already have an investment treaty regime in place, this gives rise to these kind of novel questions as to whether carbon investments in either a cap and trade system, the purchase or acquisition of carbon emissions offsets, whether they are protected under international investment law. And the recent jurisprudence under the NAFTA case, which is interesting, it was dismissed on jurisdiction, but I think the jurisdiction point was actually one of the more interesting points, because it was the question was really whether a carbon credit constitutes an investment specifically under the NAFTA. So of course, there are going to be particular considerations about the specific provisions of the NAFTA treaty, but also under the domestic law of the host state. And so what was interesting, I think, in the tribunal's analysis here was to see that they really deferred to the law of Canada and Ontario in particular to determine whether they had already attributed a property right to carbon credits. And in this particular case, they didn't really have any legislative or jurisprudential guidance because the Ontario legislature had not made a determination in that respect. The legislation didn't attribute a property right to carbon emissions credits, and there had been no case law on the issue. There is international case law on this issue. In particular, there's a leading case out of the UK. It's the Armstrong case, which does recognize a property right in emissions credits traded under the EU ETS. But interestingly, the tribunal in the Coke case declined to follow that, because although there was no direct jurisprudence in the jurisdiction, and they recognized the fact that courts in Canada would take into consideration any foreign jurisprudence on the issue. For them, they felt that the approach of the Ontario courts towards recognizing a property right in carbon credits would have been different. And in particular, they would have taken into consideration whether or not they really had this exclusive control over the credit. And so in this particular case, because it was an emissions credits that were generated under a cap and trade system, which had regulatory objectives under the climate change legislation in operation in Ontario, they felt that because of the amount of leeway that gave to the government to come in and to make changes if necessary to the regime, that was inconsistent with the notion of property in Ontario law. So all of that to say that I think much like some of the questions that I kind of alluded to in the first part of my discussion about, this inherent tension between granting more legal protections to foreign investment with the aim of attracting green investment, while at the same time trying to give more regulatory margin to maneuver to states when it comes to their climate and environmental policy. You can see how these can sometimes be at odds with each other. And if we think about just this, the theme of reform, which is the theme of this conference today, it's really, this is a novel interaction. And so it's one where we now have some interesting jurisprudence coming out of a very particular set of facts and circumstances, a particular treaty and a particular, domestic law regime. We can see how that outcome could have been different if it was taking place in a different jurisdiction in the EU or in the UK, for example, under a different treaty regime and with a different host state law, which maybe already had given proprietary status to emissions trading. So this is something then that we need to think about when it comes to policy going forward. If emissions trading systems, and particularly if linking both, voluntary agreements to link just between two individual systems that are already in operation, Switzerland and the EU as an example, or if we're thinking about it under the operation and the apparatus of Article 6 of the Paris Agreement, where the idea is to create a much more enlarged carbon market, that this is something where the potential interactions with the international investment regime should be taken into account by policymakers, because on the one hand, investment protection can be a great thing for market facilitation and ensuring that there's stability when it comes to this climate policy, but on the other hand, the potential, cost of that when it comes to making changes, should be taken into account. So I will end with that. Thank you.
Thank you very much, Jessica. And I think it's very interesting to see what are the lessons learned and what the type, at least, of future policy we are going to encounter. You mentioned, and again, I think in the to take Wendy's global view again on when we talk about the intersection of climate and arbitration and investment and climate, we need to take a global look. The last part of this webinar, and we'll extend for 10 more minutes. If you have questions, feel free to raise them now, so we can also interact with you for this last 10 minutes of the webinar. But one aspect of this intersection is related to human rights, and it ties very well also to the due diligence aspect regime of companies, which you just mentioned, Jessica. And I'll turn to Marnix to give us some final thoughts on really this when human rights consideration intersect with corporate responsibility. What do we see, and how are those human rights consideration actually influencing when we look at corporate responsibility in the context of climate change and arbitration? Marnix.
Thank you very much, Alexandra. I will shorten it a bit given the time. What I'd like to talk about is what is, I think, happening as we speak, and is as of yet not much discussed and considered, to the impact on commercial arbitration of emerging obligations on particular corporate entities with respect to climate change, in part inspired by human rights, and particularly the UN guiding principles on business and human rights. Those UN guiding principles were promulgated in 2011. They're a soft law instrument that is agreed. One of the reasons I am talking about them is actually I am based in the Netherlands, and the Netherlands has played, depending on how you look at it, a front runner role or got ahead of itself in litigation in terms of climate change. That started in 2015 with a ruling from the District Court of The Hague, in which the Dutch state was forced to basically reduce Dutch emissions, or the emissions in the Netherlands, by 20% by the year 2020. At the time, and this is already 9 years ago, but at the time, this was a pretty revolutionary judgment worldwide, where a state was held accountable. It was quite widely, at least, criticized for not respecting the separation of powers between the judiciary and the legislative power. Particularly also because the district court based it on a general civil law duty of care that the court believed the state should take into account. Particularly, the state itself was not convinced that this would survive on appeal. So, to be perfectly honest, it didn't do much. It went to appeal to the Court of Appeal of The Hague. And the Court of Appeal basically affirmed the judgment, but with a different reasoning. And that is where this comes in. It held that the obligation was actually not derived from the general civil law duty of care, but from the European Convention on Human Rights, Articles 2 and 8, and the right to life, and particularly the right to a private life. That was even more of a shocker, because now we were not in the zone anymore where the national legislative could actually intervene or have a different view. Again, I think this was deemed as fairly revolutionary, but still was very heavily criticized nationally and internationally for not respecting the separation of powers. Basically, the judiciary was intervening in matters that were matters of policy. Still, the Dutch government, there was a new government, and that new government still didn't consider this to be something that should be affirmed by the Supreme Court. So, all nuances aside, it still didn't do very much. In 2019, however, the Supreme Court actually completely affirmed the Court of Appeal's judgment, and then the Dutch state had to rush to actually get to the 20% in 2020, which eventually helped by COVID. It just about made. By that time, Friends of the Earth had been inspired by this and was taking the next step, sued Shell, at the time a Dutch-based international oil company, to take this idea further and to sue them directly based on the civil law duty of care, but to have that civil law duty of care in part, I would say in part, be inspired by the UN guiding principles on business and human rights. Now, that was a massive leap ahead, still at the time, respecting that, okay, the state could be held responsible, but what is it with a private entity with worldwide operations? And what was requested from Shell, basically, is that it reduce by 2030 its emissions, scope 1, 2, and 3, by 45% in 2030, as I said. Again, to great surprise, nationally and internationally, that was granted by the district court, with a slight caveat that on scope 3, there were significant best efforts obligations, which I think it is fair to say no one knows exactly what that means. But the district court also basically highlighted in the judgment that indeed the UN guiding principles on business on human rights played a big role for it in inspiring the finding of this duty of care of a private entity. Shell appealed. The appeal is still pending. There will in November be a judgment on this. The beginning of this year, the same Friends of the Earth took the next step. And that is to say that also in part based on the UN guiding principles, it sued, or well, it announced to be suing ING Bank, and again saying that whereas of course Shell produces gas and oil and sells it, ING Bank's issue would be two steps. One, first to have to reduce its emissions, scope 1 and 2, but also what it called financed emissions. So emissions that are essentially facilitated by ING financing corporations by now 48% by 2030. And a very separate part of that being that ING should actively engage with its customers as to whether or not they had a proper climate transition plan in place. And if not, or if that plan would not be adequate, then to ultimately disengage from these clients. Now that case has been announced and is not pending yet. But again, is based in part, if not in large part, on human rights considerations, which then inspire a general duty of care. What is a very interesting topic in this respect, and that is whether it's for an energy company like Shell or for a bank, which obviously a wholly different business with a different impact on climate change emissions and on customers, is that both of the theories rely on whether Shell or the bank basically to impose on its customers certain changes in behavior and basically to basically reduce emissions, etc., and to otherwise disengage from these customers, or at least not further invest or continue to invest in these customers or engage in lending. That and particularly on the ING side, which is simply the step further, where basically there's a whole guide in the theory that basically a requirement to disengage. That means that this will have, if that would be granted, and also if the Shell case stays, it will have a major impact on a lot of contracts. By civil law, it might actually not be allowed for a bank to simply walk away from a client it is lending money to, or let alone basically get involved in its business strategy and impose changes on that. You could also imagine joint venture contracts, basically, which obviously in the energy sector are very common on projects which are outside of the Netherlands and potentially in jurisdictions where, let's say, the status of the law has not progressed as much. Shell might be required actually to discontinue certain projects, to no longer invest in them, and thereby potentially to breach contracts governed by different laws. this development brings like a direct clash between what one could say is a public interest, business and human rights guided duty of care under, in this particular situation, Dutch law, and what basically the law governing the contract, as well as basically the jurisdiction in which actually the project is or the customer sits, allows basically under Dutch law, ING and or Shell or similar banks and companies might have certain requirements from ongoing customers, from joint venture partners, from projects that they're engaging in, potentially also with state-owned companies or states. While on the other hand, the law applicable to the contract does not allow them to do what the Dutch judgment deems them to do. I find this a very interesting topic because I think that is also what Wendy, in a way was saying. That means that we're going to have a different look, even in commercial arbitration, at applicable law, what takes precedence, basically, what are the civil law concepts that come in to basically regulate this. And that require not so much that the structure of commercial arbitration is changed, but that there will have to be a different way of looking and considering what influencing factors can be on behavior. This will be quite complicated, actually, and I think it's not far away. This will happen also under the influence of CSDDD and other EU instruments, which have similar, albeit somewhat less far-reaching obligations. That will have a lot of arbitral tribunals scratching their head as to how to deal with these things. I'd leave it at that. I don't have the answers, but it's a start to flag an upcoming issue that I'm quite convinced is going to face us pretty soon.
It's certainly opening many room for thought. Thank you very much, Marnix, for bringing that aspect also into our debate. I don't think we have any more question, and I've seen, and thank you, Isabel. You were responding to the very interesting questions on whether the EU can actually neutralize the sunset clause, which I think is a very hot and debated topic at the moment. Let me ask to each and every one of you in 30 seconds each this following wrap-up question. Is there anything, and I'd like to ask to each of you to share maybe one key takeaway or actionable recommendation that you believe is crucial for aligning arbitration practice with the urgent needs of climate change mitigation and adaptation? And I know I've been doing a lot of those very wide questions throughout the webinars, but at least we've had many insight from you. So I'll start with you, Isabel.
Thank you, Alexandre. I think perhaps I would focus on a point that I think Wendy raised, which would be, I think, well, because the reform of the treaties themselves is going to take a while. I don't think it's going to be something that happens anytime soon. I think both sort of us practitioners and tribunals need to be a little bit more sophisticated and look at sort of the international law framework more broadly. And I think a lot of those sort of principles that may not necessarily be expressly included in an investment treaty itself can definitely play a role in a specific case.
Thank you, Isabel. Beata, same question. One key takeaway or one recommendation readily.
I see, Alexandre, they're specializing in difficult questions. There's so many issues and problems. I think I would follow again, Wendy, when you are the hero today. We cannot really, that this is not really a closed up box. And I think this is what I was trying to also to say, that there are so many propositions and so many avenues by which we can go, that if you are arbitrators, that we have to really focus on all of them. Yes, not just, to have like one, because that was my main criticism about Rock Hopper, that was just 1-2 lines and not explaining why really this or the other methodology for computation of compensation was taken. So I think that this is really important, not to be closed up in one box and to be open for any other possibilities.
Thank you very much, Beata. Jessica.
Sure. Okay, 30 seconds. I think something that's been alluded to quite a few times is just the concept of ensuring that there is greater awareness of the way in which the international climate change regime is filtered down to the domestic level. Having a greater awareness of the specific objectives of a particular country's NDC when you are advising, I think, at a pre-investment stage, to make, if you are trying to advise to determine whether investment protection will extend, whether it will fall under a particular exception. It's also important to understand, domestic law when it comes to emissions trading, certainly to understand the property regime of the host state, but when it comes to also understanding the climate objectives and the particular NDCs and how that is encapsulated, and how it reflects that country's particular ambition under the climate change regime, I think is going to be of growing importance for those of us who are practicing at this intersection.
Thank you, Jessica. Marnix, since you were last, I don't want you to be last to answer the question, but same question as everybody else. If you have one key takeaway or actionable recommendation that you'd like to share with our audience today that you believe crucial for aligning arbitration practice and the urgent needs of climate change.
Well, inspired, I think, by all my co-panelists is the thought that there's a lot of intersection, there's a lot of clashing. And if I sum up, especially in investor-state arbitration, what seems to have happened is there's an enormous zeal to reform things. And in my particular view, basically politics and states have basically left the right course in basically destroying investment arbitration, particularly in Europe, instead of realizing that we're going to need trillions of investments in the energy transition only. And where we are now in a situation that investments are becoming far more uncertain, and particularly the enforcement of that protection. So there's a big risk that what everyone might have wanted to achieve by either reformation or by focusing on the fossil fuel cases, what you're forgetting is how do we actually protect the investments that we need, and that is something that I conclude from all the presentations, and something needs to be able to do that. Are we returning to gunboat diplomacy, as Wendy called it, or are we returning, for example, to investment agreements? Something needs to come in place.
Thank you very much, Marnix. Last but not least, Wendy, same question to end our discussions.
Get out of our silo. We are not, some of us commercial arbitration lawyers, some of us investment lawyers, some of us arbitration lawyers. We are all participants in this global transition, and we are all international lawyers, and we need to understand public international law, private international law, and the domestic law frameworks in the countries we're operating in order to understand how to deal with the confluence and the interface. Can I be really cheeky, Alessandra, and ask a question back to anonymous attendee? What would be, my question to you is, what would be the immediate consequence for the human species if, for example, producer states were to deactivate the mitigation obligations under the Paris Agreement? I think we have to be really careful about cutting off the nose to spite the face. If an inter se agreement between some of the parties of a multilateral treaty can vary the terms of that treaty just between those parties, be careful about what the consequences might be for some really, really important multilateral treaties like the Paris Agreement, like the UNFCCC, like some of these environmental and human rights protections. I think we just have to be careful about sticking to the basic principles of public international law.
Well, thank you very much for all your insights, words of caution, proposal of reforms, and debate. I certainly learned a lot, and thanks for all of you who stayed 15 minutes more than the anticipated time for this event, but it was fascinating, and we needed to hear more. On behalf of Jus Mundi, thank you all. I thank also my colleague Andrew Wilcox, who organized this webinar with our academic network. I thank Joey from our event, who organized the webinar itself. Thanks, of course, to you all panelists. And this webinar will be available on Jus Mundi website for you to watch again, to distribute, to share, and to engage in this discussion. Thank you very much, everyone, and have a lovely evening wherever you are. Thank you.